The person concerned has within the prescribed time taken an oath of allegiance in the form indicated in Schedule 5. 2. So much of subsection 1 as requires the taking of an oath of allegiance shall not apply to a person who a. is not of full age, or b. is already a British citizen, a British Dependent Territories citizen, a British overseas citizen, a British subject, or a citizen of any country of which Her Majesty is Queen. 3. Any provision of this Act which provides for a person to be entitled to registration as a citizen of any description or as a British subject shall have effect subject to the preceding provisions of this section. 4. A person registered under any provision of this Act as a British citizen, or as a British Dependent Territories citizen or as a British overseas citizen, or as a British subject, shall be a citizen of that description or, as the case may be, a British subject as from the date on which he is so registered. 5. A person to whom a certificate of naturalization as a British citizen or as a British Dependent Territories citizen is granted under any provision of this Act shall be a citizen of that description as from the date on which the certificate is granted. 43. In the case of any of his functions under this Act with respect to any of the matters mentioned in subsection 2, make arrangements for that function to be exercised. Part 5. 1. Subject to subsection 3, the Secretary of State may exercise of functions of Secretary of State by governors in any of the islands, by the Lieutenant Governor in 24 others. Cases concerning British citizens or British citizenship. b. In any dependent territory which is for the time being a colony, by the Governor in cases concerning British Dependent Territories citizens or British Dependent Territories citizenship. 2. The said matters are a. Registration and naturalization, and b. Renunciation, resumption and deprivation of British citizenship or British Dependent Territories citizenship. 3. Nothing in this section applies in the case of any power to make regulations or rules conferred on the Secretary of State by this Act. 4. Arrangements under subsection 1 may provide for any. Part 5. Decisions involving exercise of discretion, evidence, offences and proceedings. Such function as is there mentioned to be exercisable only with the approval of the Secretary of State. 44. 1. Any discretion vested by or under this Act in the Secretary of State, a Governor or a Lieutenant Governor shall be exercised without regard to the race, colour or religion of any person who may be affected by its exercise. 2. The Secretary of State, a Governor or a Lieutenant Governor, as the case may be, shall not be required to assign any reason for the grant or refusal of any application under this Act, the decision on which is at his discretion, and the decision of the Secretary of State or a Governor or Lieutenant Governor on any such application shall not be subject to appeal to, or review in, any court. 3. Nothing in this section affects the jurisdiction of any court to entertain proceedings of any description concerning the rights of any person under any provision of this Act. 45. 1. Every document purporting to be a notice, certificate, order or declaration, or an entry in a register, or a subscription or an oath of allegiance, given, granted or made under this Act or any of the former Nationality Acts shall be received in evidence and shall, unless the contrary is proved, be deemed to have been given, granted or made by or on behalf of the person by whom or on whose behalf it purports to have been given, granted or made. 2. Prima facie evidence of any such document may be given by the production of a document purporting to be certified as a true copy of it by sic personand in such manner as may be prescribed. 3. Any entry in a register made under this Act or any of the former Nationality Acts shall be received as evidence, and in Scotland as sufficient evidence, of the matters stated in the entry. 4. A certificate given by or on behalf of the Secretary of State that a person was at any time in Crown's service under the government of the United Kingdom or that a person's recruitment for such service took place in the United Kingdom shall, for the purposes of this Act, be conclusive evidence of that fact. 46. 1. Any person who for the purpose of procuring anything to be done or not to be done under this Act, makes any statement which he knows to be false in a material particular, or b. recklessly makes any statement which is false in a material particular, shall be liable on summary conviction in the United Kingdom to imprisonment for a term not exceeding 3 months or to a fine not exceeding £1,000, or both. 2. Any person who without reasonable excuse fails to comply with any requirement imposed on him by regulations made under this Act with respect to the delivering up of certificates of naturalization shall be liable on summary conviction in the United Kingdom to a fine not exceeding £500. 3. In the case of an offence under subsection 1, any information relating to the offence may in England and Wales be tried by a magistrate's court if it is laid within 6 months after the commission of the offence, or if it is laid within 3 years after the commission of the offence and not more than 2 months after the date certified by a chief officer of police to be the date on which evidence sufficient to justify proceedings came to the notice of an officer of his police force. And b. Summary proceedings for the offence may in Scotland be commenced within 6 months after the commission of the offence, or within 3 years after the commission of the offence and not more than 2 months after the date on which evidence sufficient in the opinion of the Lord Advocate to justify proceedings came to his knowledge, and c. A complaint charging the commission of the offence may in Northern Ireland be heard and determined by a magistrate's court if it is made within 6 months after the commission of the offence, or if it is made within 3 years after the commission of the offence and not more than 2 months after the date certified by an officer of police not below the rank of Assistant Chief Constable to be the date on which evidence sufficient to justify the proceedings came to the notice of the police in Northern Ireland. 4. For the purposes of subsection 3b, proceedings shall be deemed to be commenced on the date on which a warrant to apprehend or to cite the accused is granted, if such warrant is executed without undue delay, and a certificate of the Lord Advocate as to the date on which such evidence as is mentioned in subsection 3b came to his knowledge shall be conclusive evidence. 5. For the purposes of the trial of a person for an offence under subsection 1 or 2, the offence shall be deemed to have been committed either at the place at which it actually was committed or at any place at which he may be. Part 5. Part 5, 6, in their application to the bailiwick of Jersey subsections 1 and 2, shall have effect with the omission of the words, on summary conviction. Legitimated 47. 1. A person born out of wedlock and legitimated by the children. Subsequent marriage of his parents shall, as from the date of the marriage, be treated for the purposes of this Act as if he had been born legitimate. 2. A person shall be deemed for the purposes of this section to have been legitimated by the subsequent marriage of his parents if by the law of the place in which his father was domiciled at the time of the marriage operated immediately or subsequently to legitimate him, and not otherwise. Posthumous 48. Any reference in this Act to the status or description of children, the father or mother of a person at the time of that person's birth shall, in relation to a person born after the death of his father or mother, be construed as a reference to the status or description of the parent in question at the time of that parent's death, and where that death occurred before, and the birth occurs after, commencement, the status or description which would have been applicable to the father or mother had he or she died after commencement shall be deemed to be the status or description applicable to him or her at the time of his or her death. Registration 49. 1. After the passing of this Act, a naturalizer. T and under, a person shall not be registered under any provision British of the existing Nationality Acts as a citizen of the Nationality United Kingdom and Colonies are a British subject. Acts 1948 and 1965. B. A certificate of naturalization shall not be granted to a person under any provision of those Acts, unless I. Any fee payable by virtue of those Acts in connection with the registration or, as the case may be, the grant of the certificate has been paid, and e. Where applicable, The person in question has taken the oath of allegiance which, but for this section, he would have been required by those acts to take in connection with the registration or, as the case may be, the grant to him of the certificate. 2. Any provision of the existing Nationality Acts which provides for a person to be entitled to registration as a citizen of the United Kingdom and Colonies or a British subject shall have effect subject to subsection 1. 3. A person registered after the passing of this Act under any provision of the existing Nationality Acts as a citizen of the United Kingdom and Colonies or a British subject shall be such a citizen by registration or, as the case may be, a British subject by virtue of that provision as from the date on which he is so registered, and a person to whom a certificate of naturalization is after the passing of this Act granted under any such provision shall be a citizen of the United Kingdom and Colonies by naturalization as from the date on which the certificate is granted. 4. The following provisions of the existing Nationality Acts, namely, in the 1948 Act, Section 9 and, in Section 10, 1, the words from, and the person, onwards, and b. Section 1, 2, of the British Nationality Act 1965, shall not apply in relation to any application for registration or for a certificate of naturalization under any provision of the existing Nationality Acts, whenever made, unless the person to whom that application relates has been registered or, as the case may be, granted such a certificate before the passing of this Act. 5. In this section the existing Nationality Acts means the British Nationality Acts 1948 to 1965. 50. The 1948 Act means the British Nationality Act 1948. Alien means a person who is neither a Commonwealth citizen nor a British protected person nor a citizen of the Republic of Ireland. Association means an unincorporated body of persons. British protected person means a person who is a member of any class of persons declared to be British protected persons by an order in council for the time being in force under Section 38 or is a British pro. Part 5. 1965 c. 34. 1. In this Act, unless the context otherwise requires interpretation. 1948 c. 56. Protected person by virtue of the Solomon Islands Act 1978 cent. 15. 1978. Commencement, without more, means the commencement of this Act. Commonwealth citizen, means a person who has the status of a Commonwealth citizen under this Act. Company, means a body corporate. Crown service, means the service of the Crown, whether within Her Majesty's dominions or elsewhere. Part 5. 1870 c. 14. 1971 c. 77. 1978 c. 30. Crown service under the Government of the United Kingdom, means Crown service under Her Majesty's government in the United Kingdom or under Her Majesty's government in Northern Ireland. Dependent territory, means a territory mentioned in Schedule 6. Enactment, includes an enactment comprised in Northern Ireland legislation. Foreign country, means a country other than the United Kingdom. A dependent territory, a country mentioned in Schedule 3 and the Republic of Ireland. The former Nationality Acts means the British Nationality Acts 1948 to 1965, b. the British Nationality and Status of Aliens Acts 1914 to 1943, and c. any act repealed by the said Acts of 1914 to 1943 or by the Naturalization Act 1870. Governor, in relation to a dependent territory, includes the officer for the time being administering the government of that territory. High Commissioner, includes an acting High Commissioner. Immigration laws. In relation to the United Kingdom, means the Immigration Act 1971 and any law for purposes similar to that Act which is for the time being or has at any time been in force in any part of the United Kingdom. b. In relation to a dependent territory, means any law for purposes similar to the Immigration Act 1971 which is for the time being or has at any time been in force in that territory. The islands means the Channel Islands and the Isle of Man. Minor means a person who has not attained the age of 18 years. Prescribed means prescribed by regulations made under Section 41. Settled shall be construed in accordance with subsections 2, 2, 4. Ship includes a hovercraft. Statutory provision means any enactment or any provision contained in a subordinate legislation, as defined in Section 21, 1, of the Interpretation Act 1978, or b. any instrument of a legislative character made under any Northern Ireland legislation. The United Kingdom means Great Britain, Northern Ireland and the islands, taken together. United Kingdom Consulate means the office of a consular officer of Her Majesty's government in the United Kingdom where a register of births is kept or, where there is no such office as may be prescribed. 2. Subject to subsection 3, references in this Act to a person being settled in the United Kingdom or in a dependent territory are references to his being ordinarily resident in the United Kingdom or, as the case may be, in that territory without being subject under the immigration laws to any restriction on the period for which he may remain. 3. Subject to subsection 4, a person is not to be regarded for the purposes of this Act as having been settled in the United Kingdom at any time when he was entitled to an exemption under Part 5, Section 8, 3, or 4, b, or c, of the Immigration Act 1971 Cent. 77, 1971 unless the order under Section 8, 2, of that Act conferring the exemption in question provides otherwise, to an exemption under the said Section 8, 2, or to any corresponding exemption under the former immigration laws, or b. as having been settled in a dependent territory at any time when he was under the immigration laws entitled to any exemption corresponding to any such exemption as is mentioned in paragraph a, that paragraph being for the purposes of this paragraph read as if the words from unless to otherwise were omitted. 4. A person to whom a child is born in the United Kingdom after commencement is to be regarded for the purposes of Section 1, 1, as being settled in the United Kingdom at the time of the birth if he would fall to be so regarded but for his being at that time entitled to an exemption under Section 8, 3, of the Immigration Act 1971, and b. immediately before he became entitled to that exemption he was settled in the United Kingdom, and c. he was ordinarily resident in the United Kingdom from the time when he became entitled to that exemption to the time of the birth. But this subsection shall not apply if at the time of the birth the child's father or mother is a person on whom any immunity from jurisdiction is conferred by or under the Diplomatic Privy 1964 c. 81. Lieges Act 1964. Part 5. 1914. Cent. 17. 1970 c. 14. 1967 c. 4. 5. It is hereby declared that a person is not to be treated for the purpose of any provision of this Act as ordinarily resident in the United Kingdom or in a dependent territory at a time when he is in the United Kingdom or, as the case may be, in that territory in breach of the immigration laws. 6. For the purposes of this Act. A person shall be taken to have been naturalized in the United Kingdom if, but only if, he is a person to whom a certificate of naturalization was granted under any of the former Nationality Acts by the Secretary of State or, in any of the islands, by the Lieutenant Governor, or a person who by virtue of Section 27, 2, of the British Nationality and Status of Aliens Act 1914 was deemed to be a person to whom a certificate of naturalization was granted, if the certificate of naturalization in which his name was included was granted by the Secretary of State, or a person who by virtue of Section 10, 5, of the Naturalization Act 1870 was deemed to be a naturalized British subject by reason of his residence with his father or mother. b. A person shall be taken to have been naturalized in a dependent territory if, but only if, he is I. A person to whom a certificate of naturalization was granted under any of the former Nationality Acts by the governor of that territory or by a person for the time being specified in a direction given in relation to that territory under paragraph 4 of Schedule 3 to the West Indies Act 1967 or for the time being holding an office so specified, or e. a person who by virtue of the said section 27, 2, was deemed to be a person to whom a certificate of naturalization was granted, if the certificate of naturalization in which his name was included was granted by the governor of that territory, or e. a person who by the law in force in that territory enjoyed the privileges of naturalization within that territory only. And references in this act to naturalization in the United Kingdom or in a dependent territory shall be construed accordingly. 7. For the purposes of this act, a person born outside the United Kingdom aboard a ship or aircraft shall be deemed to have been born in the United Kingdom if I. At the time of the birth his father or mother was a British citizen, or e. He would, but for this subsection, have been born stateless. And, in either case, at the time of the birth the ship or aircraft was registered in the United Kingdom or was an unregistered ship or aircraft of the government of the United Kingdom, but b. subject to paragraph a. is to be regarded as born outside the United Kingdom, whoever was the owner of the ship or aircraft at that time, and irrespective of whether or where it was then registered. The preceding provisions of this subsection shall apply in relation to each dependent territory with the substitution for the references to the United Kingdom and to a British citizen of references to that territory and to a British dependent territory's citizen respectively. 8. For the purposes of this Act an application under any provision thereof shall be taken to have been made at the time of its receipt by a person authorized to receive it on behalf of the person to whom it is made, and references in this Act to the date of such an application are references to the date of its receipt by a person so authorized. 9. For the purposes of this Act, the relationship of mother and child shall be taken to exist between a woman and any child, legitimate or illegitimate, born to her, but b. subject to section 47. The relationship of father and child shall be taken to exist only between a man and any legitimate child born to him. And the expressions, mother, father, parent, child, and descended, shall be construed accordingly. 10. For the purposes of this Act, a period, from, or, to, a specified date includes that date, and b. any reference to a day on which a person was absent from the United Kingdom or from a dependent territory or from the dependent territories is a reference to a day for the whole of which he was so absent. 11. For the purposes of this Act, a person is of full age if he has attained the age of 18 years, and of full capacity if he is not of unsound mind, and b. a person attains any particular age at the beginning of the relevant anniversary of the date of his birth. Part 2p. Part 5. Part 5. Meaning of certain expressions relating to nationality in other acts and instruments. 12. References in this Act to any country mentioned in Schedule 3 include references to the dependencies of that country. 13. Her Majesty may by order in Council subject to annulment in pursuance of a resolution of either House of Parliament amend Schedule 6 in any of the following circumstances, namely, where the name of any territory mentioned in it is altered, or b. where any territory mentioned in it is divided into two or more territories. 51. 1. Without prejudice to subsection 3, c. in any enactment or instrument whatever passed or made before commencement, British subject, and Commonwealth citizen, have the same meaning, that is, in relation to any time before commencement. A person who under the 1948 Act was at that time a citizen of the United Kingdom and colonies or who, under any enactment then in force in a country mentioned in section 1(3) of that Act as then in force, was at that time a citizen of that country, and any other person who had at that time the status of a British subject under that Act or any other enactment then in force. b. In relation to any time after commencement, a person who has the status of a Commonwealth citizen under this Act. 2. In any enactment or instrument whatever passed or made after commencement. British subject means a person who has the status of a British subject under this Act. Commonwealth citizen means a person who has the status of a Commonwealth citizen under this Act. 3. In any enactment or instrument whatever passed or made before commencement. A citizen of the United Kingdom and Colonies. In relation to any time before commencement, means a person who under the 1948 Act was at that time a citizen of the United Kingdom and Colonies. In relation to any time after commencement, means a person who under this Act is a British citizen, a British Dependent Territories citizen or a British overseas citizen. b. Any reference to ceasing to be a citizen of the United Kingdom and Colonies shall, in relation to any time after commencement, be construed as a reference to becoming a person who is neither a British citizen nor a British Dependent Territories citizen nor a British overseas citizen. c. Any reference to a person who is a British subject, or a British subject without citizenship, by virtue of Section 2, 13, or 16 of the 1948 Act or by virtue of, or of Section 1 of, the British Nationality Act 1965 shall, in relation to any time after commencement, be construed as a reference to a person who under this Act is a British subject. 4. In any statutory provision, whether passed or made before or after commencement, and in any other instrument whatever made after commencement, alien, in relation to any time after commencement, means a person who is neither a Commonwealth citizen nor a British protected person nor a citizen of the Republic of Ireland. 5. The preceding provisions of this section shall not apply in cases where the context otherwise requires, and b. shall not apply to this Act or to any instrument made under this Act. 52. Part 5. 1965 Cent. 34. 1. In any enactment or instrument whatever passed or consequential made before commencement, for any reference to Section 1, 3, of amendments, the 1948 Act, list of countries whose citizens are common transitional wealth citizens under that Act, there shall be substituted a reference to Schedule 3 to this Act, unless the context makes that substitution inappropriate. 2. Subject to subsection 3, Her Majesty may by order in Council make such consequential modifications of any enactment of the Parliament of the United Kingdom passed before commencement. 6. Any provision contained in any Northern Ireland legislation passed or made before commencement, or c. any instrument made before commencement under any such enactment or provision, as appear to her necessary or expedient for preserving after commencement the substantive effect of that enactment, provision or instrument. 3. Subsection 2, shall not apply in relation to the Immigration Act 1971, or b. any provision of this Act not contained in Schedule 7. p. 2. Provisions, Repeals and Savings. 1971 Cent. 77. Part 5. 1978 C. 30. Citation, Commencement and Extent. 1971 C. 77. 1967 C. 4. 4. Any order in Council made under subsection 2 shall be subject to annulment in pursuance of a resolution of either House of Parliament. 5. Any provision made by order in Council under subsection 2 after commencement may be made with retrospective effect as from commencement or any later date. 6. The enactments specified in Schedule 7 shall have effect subject to the amendments there specified, being amendments consequential on the provisions of this Act. 7. This Act shall have effect subject to the transitional provisions contained in Schedule 8. 8. The enactments mentioned in Schedule 9 are hereby repealed to the extent specified in the third column of that schedule. 9. Without prejudice to Section 51, Nothing in this Act affects the operation, in relation to any time before commencement, of any statutory provision passed or made before commencement. 10. Nothing in this Act shall be taken as prejudicing the operation of Sections 16 and 17 of the Interpretation Act 1978, which relate to the effect of repeals. 11. In this section, modifications includes additions, omissions and alterations. 53. 1. This Act may be cited as the British Nationality Act. 1981. 2. This Act, except the provisions mentioned in subsection 3, shall come into force on such day as the Secretary of State may by order made by statutory instrument appoint, and references to the commencement of this Act shall be construed as references to the beginning of that day. 3. Section 49 and this section shall come into force on the passing of this Act. 4. This Act extends to Northern Ireland. 5. The provisions of this Act, except those mentioned in subsection 7, extend to the islands and all dependent territories, and Section 36 of the Immigration Act 1971, power to extend provisions of that Act to islands, shall apply to the said excepted provisions as if they were provisions of that Act. 6. For the purposes of Section 3 of the West Indies Act 1967, it is hereby declared that the provisions of this Act, except those mentioned in subsection 7, extend to all associated states.